Hi, let's talk about Advocate Healthcare Network against Stapleton, which is a case pending in the United States Supreme Court. They had arguments on March 27, and it deals with ERISA church plans. Now, ERISA specifically exempts church plans, and the original definition adopted by Congress in the 1970s says this is a plan that is established and, notice the and, maintained by a church or a church-related organization. In the 1980s, however, Congress adopted an amendment to the statute, and they talked in there about a church plan that is maintained by a church-related organization. Doesn't say anything about how it was originally established. So what's happened is that churches have acquired organizations like hospitals and schools, mostly hospitals, that were originally, where the ERISA plan was originally established by a non-church and now is being maintained by a church or church-related organization. So after that amendment in the 80s, there were 3 government agencies that put out letters indicating that, oh, this is okay if you're maintaining it as a church. It's still a church plan, even though the ERISA plan wasn't originally established by a church. The problem is there are 3 circuit court cases, the Third Circuit, the Seventh Circuit, the Ninth Circuit, who've held no. To be exempt as a church plan, you have to have been originally established by a church, and plan has to be maintained by a church. So now we've got very complicated statutory arguments that I'm not going to go into, and a big question about how much deference the Supreme Court should give to these 3 government agencies that have been putting out these letters for the past 30 years. Meanwhile, how much is involved? One of the lawyers in the argument said $66 billion, that's billion with a B, dollars. So let's wait until June and see how the Supreme Court decides this case. Thanks for watching.